Good afternoon. We might make a start. I'm Dr. Nathan Gibson, the Chief Psychiatrist. Just a bit of housekeeping before we start. You're all muted to reduce the background noise. You obviously know how to use the questions for the webinar. You can use the chat box. We'll try and keep the questions to the end, but if there are any burning questions during the presentation, I'm happy to keep an eye out for them and try and answer them at the time. If there's any issues with regard to hearing me, please let Laura know, and she'll fix that up. She'll either fix me up or she'll fix up the process. So we'll start the ball rolling. So we're talking today about changes to the Mental Health Act, and this is a webinar specifically aimed at general practitioners. Now, this is not a formal education program. It's really a broad, if you like, information session, and I'll be talking to you at the end about how you might access further information and the resources that you might need. So, how will the new Mental Health Act affect you and your practice? Probably pretty rarely, really, because we know that GPs, in most cases, depending on your sort of practice, of course, in most cases, you would be using it rarely, but it's important to know because of the expansion with regard to the Mental Health Act into voluntary patient realm. So what do you need to know prior to the implementation of the new Mental Health Act, and where can you get help and access resources about the new Act? The Act was passed last year, but commences in essentially just over 3 weeks' time. It legislates for current best practice in mental health, but can I say that best practice is really clinical best practice. Mental health legislation can't cover all potential issues that you find in clinical practice, and therefore legislation provides a framework around rights. But for me, best practice still sits within a clinical remit and clinical standards. So the Act is really only one part of our broad clinical practice. What are the new features of the Mental Health Act? There's a charter of mental health care principles, and every doctor in the state will be receiving an information for referring practitioners package, which will have, and we'll talk about that at the end, but has the charter of mental health care principles. These are broad principles about what we would expect as individuals when we go and seek health care. They're similar to the national principles for mental health, and they're really 15 common sense principles around working with an individual and their families. This Act has more rights for patients, more rights for carers. It's the first time that carers have really been embedded in the Mental Health Act, and whilst there are still some confidentiality issues with regard to patients, carers have a much greater expectation that they will be contacted, and we'll go on to talk about when we'll need to contact carers as defined by the Act. There is greater clinical accountability for actual administrative accountability as well for clinicians. Unfortunately, there is extra paperwork. Having said that, it's mostly for those staff working in mental health services rather than referring agents. And we'll talk about for what extra forms or new forms there are for referring agents. The big change is this is a capacity-based Act. So if you'll remember, the current Act, the 96 Act, says you have to suffer from mental illness, be a risk, and refuse treatment. There is a comment about capacity in there, but it can be overridden. In the 2014 Act, it really is focused on capacity. So the person must have capacity, and we'll go on to talk about that. So we have one question coming up. I just can't see the actual question that's being asked. Okay, I'll leave that, and if that question comes up further, I'll address that from Linda or Sue. So Laura, how do I look at these questions? They're just coming up as a yes. Are you able to tell me how I open these questions?
Those questions have been fixed, they were slideshow.
Oh, great. Sorry, no, thanks for that. They're all slideshow questions, so great. I'll just press on. So, okay, let's move on. So the scope is generally the same. It focuses on involuntary patients predominantly, although it does have some comments around voluntary patients. And it's really about how to refer someone and when to refer someone for examination by a psychiatrist under the Act. Some things remain unchanged. A person is assessed by a practitioner. The practitioner considers whether the person needs or meets the criteria for involuntary treatment. Then if so, the person's referred to a psychiatrist, and the person may be detained or transported to see that psychiatrist. There are some changes though, and we'll go through these. So who can refer under the Mental Health Act? It's the same as now. All doctors can refer for assessment under the Mental Health Act. If you're an intern, if you're a haematologist, if you're a psychiatrist, if you're a GP, you can refer. Authorised mental health practitioners are psychologists, OTs, social workers, and mental health nurses who've had specific experience in mental health over several years, and they undertake a specific course through the Office of Chief Psychiatrist, and they can be designated authorised, and they can also refer. So when can a referral be made? It's the same as now. If the practitioner assesses the person and reasonably suspects that the person meets the criteria for an involuntary treatment order, you can refer. And that's the important difference. A psychiatrist who's assessing the person has a higher level of assessment to make with regard to whether a person is deemed to have a mental illness. But a referrer only needs to suspect, and we'll talk about that. So how do we define mental illness? Similar to now, a disturbance of thought, mood, volition, perception, orientation, or memory. Pretty broad, you might say. And this Act actually does specify that we're bound to consider standard categorical systems such as ICD-10 or DSM-5, but they're pretty broad, really. And the mental illness must significantly impair, temporarily or permanently, judgment or behaviour. There are a number of exclusions, and I'll talk a little bit about that. For example, if someone is using alcohol, that's an exclusion. What does that mean? What it means is if someone is drunk, you can't put them under the Mental Health Act just because they're drunk or just because they're dependent on alcohol. If that person is drunk or dependent on alcohol and saying they're suicidal, and you suspect that they may be mentally unwell from a mental illness perspective, you can use the Mental Health Act. So if you can see that subtle difference, for example, if someone is behaving badly in the street, you can't put them under the Mental Health Act just because they're behaving badly or promiscuous or have certain beliefs or have a certain religious persuasion. But certainly, if that behaviour or those beliefs are very much tied up within a mental illness as defined, yes, you can consider the Mental Health Act. A big one is drug-induced psychosis. I often hear people say, oh, well, it's just the drugs causing them to be psychotic, therefore it's not a real mental illness. But yes, drug-induced psychosis is a mental illness. It's different than drug intoxication. Drug-induced psychosis is quite separate, of course. And someone who has a drug-induced psychosis can be made an involuntary patient. Now, the practical issue is, do you want to send everyone who is drunk and saying they're suicidal, do you want all of those people to be under the Mental Health Act and sent to an authorised unit? The answer is probably no. The practical issue is that if someone is drunk and feeling suicidal, it's really most helpful for them in an emergency department, for example, to be sobered up and then to have a proper assessment so that you can get a better understanding of what that person's underlying mental state is. So what are the criteria for an involuntary treatment order or for referral? So the person has to be suffering or suspected of suffering from a mental illness, as we've talked about. They must be a significant risk to the health or safety of themselves or others. So significant means, you know, it might not be that they just might do something maybe and it's unlikely. It has to be a significant risk. Previously, the Mental Health Act has had reputation, relationships and property in. They've been taken out and they've been replaced by harm, a significant risk of harm. And what does that actually mean? Well, it's yet to be really fully defined, but it probably expands the criteria a little bit. So if there's a broad risk of harm and you can make a case that harm will come to that person in some form, then you can consider the Mental Health Act. And I think this will be defined as time goes on. That no less restrictive option is available. Now, as an example, you might have someone who's very unwell with psychosis, but you may have an extended family who say, look, we can provide 24-hour really intensive support and care. We'll be watching the person all the time. They're going to take their medication. We prefer that they're treated at home. We'll bring them back to see you tomorrow. That might, in fact, be reasonable if you agree that that can occur and that they can provide that level of care. And so you might say, well, this person is potentially able to go under the Act, but there is a less restrictive option available. It really is a clinical decision. If you judge that what appears to be a less restrictive option is not really viable, then you probably should proceed to a referral under the Mental Health Act. Now here's the biggie. This is the new one. It used to be if the person was refusing treatment, but now it's that the person does not demonstrate the capacity to make a treatment decision. So, what is capacity under the new Mental Health Act? This is how they define it, that the person, with regard to a specific decision, which is around their treatment for mental illness, do they understand the information or advice about the decision? Thus, have they been provided with, appropriate information in a way they can understand and in a time that they can use to understand it? Do they understand all the matters involved in making the decision? Do they understand the effect of the decision? What happens if they do or don't have treatment? Can they weigh up all the factors? Can they weigh up all the pros and cons? And can they communicate that in some way? So that's not just necessarily verbally, in writing or through other methods. What does that mean practically? So practically, once they've been given appropriate information in a way that they can understand, can they actually understand the impact of the decision? Can they weigh up the pros and cons of making that decision, and can they communicate this? Now there are various different tools you can use to assess capacity. Many of them are quite extensive and take a half an hour. We realise practically that most people, when they're in such an agitated state, it's not going to be possible to do a really extensive capacity assessment. And that's the benefit for referrers. You only have to suspect that they lack capacity. So my recommendation would be that you make some initial assessment of capacity as much as you can and make a decision based on that. Document that and make a decision based on that. But there's not really an expectation that a referrer would spend 45 minutes assessing capacity. It's just not practically reasonable. So, and particularly if someone's agitated and sitting in your waiting room or sitting in your room, it's, you know, you're going to have to move a bit faster than that. So, capacity is an interesting concept. There are various capacity training modules. We run a capacity training module from the Office of Chief Psychiatrist. Down the track, we'll look at having these on our website, on my website. So there'll be more detailed information about this. But at this stage, I would use those criteria that they have, and really, if you've got any queries or questions about that, speak to your local mental health service, or we'll talk about the help desk that you can access. But that's the biggest, that capacity is the biggest change. And I anticipate that it'll take a bit of time for practitioners to really get a grip of what that practically means consistently for them, because it's a big change. Capacity is probably a fairer way to do it. The College of Psychiatry was very supportive of a capacity-based act. Tasmania was the first to have a capacity-based act in Australia. It's unusual for us to be following Tasmania, but we are. The interesting thing was, and I know I can't hear you, but I often ask, after the capacity-based act came in Tasmania, do people think that the number of involuntary patients went down or up? And most people would say, oh, well, if people have capacity, then it's going to be harder to put them under the Mental Health Act, and so they would have naturally gone down. Interestingly, the numbers of involuntary patients in Tasmania per capita have gone up. Go figure. I don't quite understand why or how that's happened, but I guess it just shows that the mental health legislation can be complex, and clinicians will make their own decision as they're assessing a patient. So as we mentioned, to assess capacity, you must provide appropriate information to the person in a way that they can understand and with enough time for them to consider it. Again, we're fraught with the practical realities that if you've got a very agitated person, you may not have time to give them all the information or give them time to actually consider it. You know, somebody is very agitated saying, I'm going to walk out of here in a few minutes. You may need to make as good an assessment of capacity as you can within the time that you've actually got with that patient. And I think the Act really understands this. And again, I reiterate that you only have to suspect that they lack capacity. So do your best, but I think if you've done your best and documented what you can, you won't be criticised for that at all. It's up to the consultant psychiatrist when he or she sees the person in either an authorised hospital or another place to make a more detailed assessment of capacity. Children are represented in this Mental Health Act. Interestingly, 18-year-olds or 18-year-olds or older are assumed to have capacity unless shown not to, but children are deemed to automatically lack capacity unless they're shown to have capacity. And you'll probably be aware of the concept of the mature minor across medicine. It applies also within the Act, so that if a child is deemed to have capacity, they may in fact be able to make decisions of their own. But that's primarily an issue, I think, for the consultant psychiatrist assessing the child, although it may be an issue if you've got a 16 or 17-year-old in your practice considering whether they can or not. Despite whether a child has capacity to make a decision, there's still a requirement to try and engage the parents wherever possible under this Act. Okay, so How must an assessment be conducted? You must see someone face to face. We've had scenarios in the past where rural GPs who perhaps haven't had access to timely training have gone on advice of a nurse in another town to say that someone's unwell. The GP hasn't seen the person and they've put them on forms. That's not a valid referral. A valid referral requires you to actually assess the person face to face. So if someone can be through on the other side of a door and you might just be able to vaguely see them and speak with them if you're going to see them at their home, but you can't do an assessment over the telephone. Now that's all good for the metro area, but we've acknowledged that in the rural setting, in the non-metro setting, so areas essentially outside of Perth, that at times it may not be practical to assess face-to-face, and you can use audio-visual, so video, telehealth. In that situation, wherever the patient is, they must have some sort of health professional. For example, they must have the local rural nurse. It doesn't have to be a mental health nurse, but the local rural nurse with them at all times during that assessment. So you can potentially assess someone via telelink, video link, with a nurse sitting beside them at the other end. And if you believe they need a referral to a psychiatrist, you can do a referral under the Mental Health Act in that situation in a non-metro area. So that will open up some flexibility, some appropriate flexibility, we believe. So how do you make the referral? Like now, you have to have seen the person within 48 hours. If you saw them 3 days ago, you can't use the Act. What I haven't noted here, and I think it's important to note, is that regardless of whether a doctor sees someone, the police can still bring someone in under the Mental Health Act to a place of safety for assessment. So if the local police or nurse say to you, we haven't seen this person, or we know this person is around and about, they're acting this way, even if you haven't seen them, you may have a discussion with the police and say, look, I think we need to bring this person in. And the police will have capacity under the Mental Health Act to pluck the person off the street or from their home and bring them in for an assessment. I haven't got that on the slides, but that's an omission. But I think it's important to note that function. It exists now under this Act, and it will exist under the new Act as well. But back to your own referral. See them within 48 hours. The Form 1 that we've got now becomes the Form 1A, and it's a referral for examination by a psychiatrist. Just remember, you don't have to send them to an authorised hospital for assessment. If you know a psychiatrist is going to be at a certain place within 24 hours, and you know that place is a reasonably safe place for the person to be sent, you can actually write the name of that place on the form. So it doesn't need to be an authorised hospital. In most cases, a person will be referred to an authorised hospital, but the other place option exists. Now, what we've done with the new Act is we've got an attachment to the Form 1A. Under Mental Health Act 2014, you have to give a copy of the information on the referral form to the patient. So that's new. To sort out the issues regarding sensitivities, there is an attachment to the Form 1A, and that's where you can write the sensitive information from third parties that you really can't release to the person. And that Form 1A attachment will not be given to the individual. They'll get the Form 1A, but not the attachment. So I think that's probably helpful for referrers so that they can put down information they need to put down. Can that person ever get access to those forms? They may make, those forms might be subpoenaed in court. It's possible in a court process that they might be released. So it's never absolute, but in any freedom of information process or process through the Mental Health Act where patients can access their forms and information, they will not receive that attachment. So what do you write on a Form 1A? I do get a few questions from GPs about this. The Form 1A, or the referral form, is not a clinical handover form. I know it's sometimes used that way. I've had some GPs say, well, you haven't left enough space on the form to write all the clinical handover. These forms are really just a legal form specifying why someone needs to be made involuntary as per the criteria, and we'll give an example of that shortly. Remember, it's not appropriate to write 1 or 2 words. I've seen forms where somebody has written mad or crazy. Now, apart from being really unfortunate terminology that should have gone out with the dark ages and really inappropriate for clinicians to use in this sort of situation, it doesn't actually meet the criteria for providing enough information on the form. But you still have to be brief. It's not an essay, it's just specifying the criteria as to why they need to be referred for an assessment. So it's also not a handover document. I absolutely appreciate the practical limitations for GPs and time limitations, as well as the issue of you don't want to do a half a dozen forms. You want to make it as streamlined as possible. But these are just legal documents, and the clinical information you need to include probably should be in your clinical referral. So here's an example. You might write on the Form 1A, Mr. Smith has evidence of significant psychosis that's placing him or others at risk. He lacks capacity. I think that would be sufficient. So really, essentially, one line that covers 3 or 4 of the criteria, that covers your criteria. Third-party information. Mr. Smith has been keeping a weapon under his pillow. If that's really sensitive and it's given to you by his wife, you might put that on the attachment. So this is the information provided to you. But if Mr. Smith has said, well, I've been keeping a knife under my pillow, you might actually write that on the Form 1A. So it really does depend how sensitive that information is. And that would probably be enough information to make that legal referral. So just as a reminder, you can't refer a patient on third-party observations only. You must see the person. Having said that, if you see someone and you've got this really heavy-duty third-party information that he's been hiding a knife under his pillow, that he's been shouting at the stars, that he's been not sleeping for 3 days, that's really strong information that can be enough to make your decision. And you might have a situation where Mr. Smith refuses to speak to you. In that situation, you can still put Mr. Smith on forms. You've got enough information from third parties that shows the level of risk. You've seen Mr. Smith. Even though Mr. Smith refuses to speak to you, you can still refer Mr. Smith. So I hope you can see the difference there. You can't just write third-party information and not see him. But if you see Mr. Smith, your third-party information can provide the bulk of your criteria for referral under the Act. So just a reminder that the patient will see a copy of the Form 1A and to put your sensitive third-party information on the attachment. So what's the time frame for referral? This has changed. It used to be 7 days. It's now 3 days from when the referral is made. So if you don't get the person to the authorised hospital or to the other specified place within 3 days, the form automatically lapses. And the new change is that it can also be revoked. So if you decide a few hours later that in fact you don't need the form at all, you can revoke the form. We had a kind of convoluted process for doing that revocation before, but now it's specified on the form. And it doesn't have to be the same doctor to revoke the form, but really there is an onus that if you're going to revoke a form that somebody else has written, that you try and speak to the person that wrote the form so that you can be absolutely sure about whether you should be revoking that form or not. Now, 3 days doesn't seem like a long time when you're in Balgo or elsewhere. If you're reined in, if it's difficult getting RFDS, etc. In non-metropolitan areas, that 3 days can be extended for another 3 days as well, using a 1B variation of referral form. So you can get 6 days to get someone to be seen by a psychiatrist. So we're acknowledging the needs of broader WA. Under the old Act, it was actually silent as to how you could detain someone while you were referring them. The new Act has become more specific. So if you've got someone on a referral form and they're saying, and they're in the local ED and they're saying, I'm not going to stay, you can actually do a detention order, a Form 3A, to hold them while you're referring them. And you can use reasonable force under common law duty of care to hold them. Also, if they leave, you can do an apprehension and return order to bring them back under the Act. So these are picking up, I guess, gaps that we had in the current Act so that it's clearer in the new Act. The detention order is valid for 24 hours, so you have to update that every 24 hours if you need to continue that detention order. Those detention orders will only last as long as the referral order lasts. And if the referral order expires, the detention order expires as well. So just in summary again, same sort of referral process, but now you can also sign a detention form, a Form 3A, where you're believing that you actually need to detain the person while they're being referred. Transport. We used to have a Form 3 for transport. Now it's a Form 4A. And it's the same thing. It's about transporting the person to the authorised hospital or to that other place with a referral. The transport orders only last as long as the referral orders last. You might have heard about transport officers. Under the new Act, a third-party provider can actually provide transport for an individual. Now, these are a specified third-party provider that the government will specify. There's a tender out now for them to identify who is going to be the transport providers under the Mental Health Act. And they will be trained and it will be clear about their remit. It's a bit unclear yet as to how they might operate in the country. They may in fact not operate in the country, so we need to wait and see whether they will or whether they'll just be metro-centric as as unfortunately happens now under the current trial. The big issue is police can still be involved in transfers. The practical issue is you might find that once the new Act comes in, police on the scene might say, oh, the new Act says the police don't have to be involved. You can be very clear to the police and say, look, that's not actually true. Under the new Act, the police still can become involved, and certainly if there's no transport officer available, it's very clear the police do need to become involved. So we're working very closely with the police to ensure that they're absolutely clear about that. We're trying to reduce the burden on police so that they can go off and do other stuff that they really need to do as well. But if they need to assist in a transfer, particularly in the non-metro areas, then the police will need to be involved and can be involved under the Mental Health Act. Again, transport, as we said, is valid for the same length of time as the referral, 3 days, and can be extended. Once the referral is revoked, the transport order is revoked. So you can't transport someone without a referral. One of the questions that's been asked is, what happens if you've got the extension form, but you can't find the original referral form, or you can't find the original transport order, but you've got the extension? That doesn't matter. As long as you've got the current form, that's all you need. So, what happens if you need to give someone medication while they're being referred? This is similar to the current Act. Emergency psychiatric treatment, and it's emergency psychiatric treatment, not emergency physical treatment. So you can't treat someone's diabetes under this part of the law. But emergency psychiatric treatment, let's say someone needs an injection of olanzapine, an injection of clonazepam, even an oral medication, but they're not keen to take it, then you can actually provide that to them under emergency psychiatric treatment while they're waiting to reach the authorised hospital. You do have to fill out a form, and you do have to send that form in to the chief psychiatrist. You can only use that in the situation where it's life-saving. You know, the example where you're in a local regional ED, the person's extremely agitated, is being restrained and given medication, because if you let them go, they're going to hurt themselves or hurt others. So it's pretty strict criteria. If you ask most emergency department physicians, they will tell you that they usually don't operate under emergency psychiatric treatment. They just use general duty of care. Now, I obviously encourage anyone who's being treated for mental illness in an emergency situation to be put under emergency psychiatric treatment, but it's the choice of the clinician. Some clinicians will say, well, even though there's more protection for me under the law if I use emergency psychiatric treatment and do the forms, I'll just choose to use duty of care because I've always done that. So just to make you aware of that. Now, you might hear of seclusion and restraint under the new Mental Health Act. Seclusion and restraint, as defined by Mental Health Act 2014, only refers to authorised hospital. So if you're holding someone down or detaining someone in a country, in a rural ED, that's different than seclusion and restraint. So you might say, oh my God, look, there are so many forms to fill out for seclusion and restraint. You don't have to worry about filling out those forms. Having said that, if you're restraining someone in an ED setting, you should be documenting that carefully as good clinical practice. So it's just to make that differentiation because I've been asked about that. Culture-wise, we're one of the first acts in Australia, and in fact probably the first, to include ATSI people within the Act. If you're assessing someone to refer them to a psychiatrist, to put them on a Form 1A, you are obliged, if it's an Aboriginal or Torres Strait Islander, to offer them the opportunity to have someone culturally appropriate with them while you're assessing them. Now, they might say, yeah, my Uncle Bob is in the next room, can he come in? And you'd say, yeah, sure. They might say, my Uncle Bob's in Sydney at the moment, I want him, I'm not going to, you can't assess me unless Uncle Bob's with me. Well, that's not quite right. You might say, oh, well, let's get Uncle Bob on the telephone. Uncle Bob might not be available on the telephone. You might say, look, I'm really sorry, we can't get Uncle Bob, but we still need to proceed with the assessment. Is there anyone else? But we still need to proceed with the assessment. So you're not absolutely obligated, but you do need to make an attempt. And that person doesn't need to be a healthcare worker who comes in with them, just a culturally appropriate or significant person. Who determines significance? It's the person themselves that determines significance. The other new thing under the Act are things called notifiable events. You might recall I mentioned that we're now obligated to engage carers more under this new Act 2014. There's actually 25 notifiable events where you must contact a personal support person, which usually means the carer or next of kin or a nominated person. There are 25 times during the Act when we have to do this. Thankfully for referrers, there's only essentially 4 or 5 times where this might occur. And of course, it's good practice. If you're putting someone under the Act, you probably want to have a chat with their mother, their spouse, their sister, their brother, just so that they know what's going on, because it can be a pretty stressful time for families when someone's being put under the Act, and they might have some strong views about this. Families have often given you information which has enabled you to put someone under the Act. So you must contact who's the nominated kind of personal support person if you're putting someone on a detention order, taking them off a detention order, or making a transport order. You have to call or contact their carer, personal support person. Now they might say, oh, I've got 6 brothers and sisters, I want you to call them all. Well, no, you don't need to. You only need to call one, and that's the, if you like, the main nominated person. What happens if, you know, the person doesn't have a nominated person? Well, you don't need to actually call anyone, but it's good practice to try and find someone who can keep an eye, you know, who knows them. What happens if you ring the next of kin and it just goes to message bank? Well, if you've made a good attempt to try and call them, that's a pretty good effort. You're not expected to try and call someone 10 times or, you know, try 6 different people to try and contact them. If you've made a good attempt to call the person, you can be assured, of course, that once the person gets to an authorised hospital, there'll be other times when the psychiatrist or others have to call the family. So there are checks and balances along the way. So just be aware of that new requirement under the Act, the notifiable event. So I can just note some questions coming up. Just excuse me while I just flick through and see if there's anything there that I can help with. Okay. Can we request police if we are concerned re-level of escalation of violence from Sue? Yes, you can request the police, Sue. As I said, even if you haven't seen the person and you know they're out in the community, you can ask the police to go and bring them in. You could ask the police to stay with you. There's no point in you assessing a person if you believe you are at risk. It's not in the Act, but it's a practical clinical thing that if you are trying to assess someone and you think they're a high risk of assaulting you, hurting themselves, absconding, of course, it'd be very reasonable to ask the police or other appropriate services if they could stay to assist you while you're doing that that assessment. Hopefully that's answered that question. Okay, I'm sorry, I'll just get back. Person's rights. These are the rights of the person, and you just need to ensure that people are made aware of their rights. And can I say the Mental Health Commission, who's the agency responsible for the Act, I'm not, my office and myself, I'm not directly responsible for the whole Act. I'm responsible for certain components, but it's the Mental Health Commission that are overall responsible for the Mental Health Act. They're producing some brochures that will be available online, and we'll talk about them at the end. But you must advise the person about their rights. You must advise them that they have the opportunity, and that they get the opportunity means to contact people while they're being detained. So they can call a lawyer, they can call their mum. Obviously, if they're going to call their mum or their dad and threaten to kill them, you might want to. You can potentially say, well, no, I don't think you should do that. But if they're looking to get advocacy, yes, absolutely. They have a right to access the Mental Health Advocacy Service. Now, the Mental Health Advocacy Service are the old Council of Official Visitors. So they have a right to ring them as a referred person. This is new in the Act. Previously, the Council of Official Visitors only dealt with inpatients or hostel patients or people on community treatment orders. But now they can support people who are referred as well. And usually what people will want to know is, I shouldn't be referred, I want to get off this order, I want you to get me off the order. The Advocacy Service can't get people off orders, but they can provide advice around their rights. You have to let people know that why the referral was made, and usually, as I said earlier, you'll be just giving the person a copy of the Form 1A, not the attachment, just the Form 1A, with some fairly neutral language about why they've been referred. You know, Mrs. Bloggs is depressed and currently at high risk of hurting herself, and I suspect she lacks capacity. That's it. That's probably all you need to write on the form. You also need to let people know they've got a right to make a complaint. It's just kind of standard practice. The best way to do it is to just give them a brochure that you download from the Mental Health Commission's website, and we'll talk about that at the end. I'm aware of time, so I'm going to press on a little bit. What happens once they get to hospital? Same as now, seen by a psychiatrist, shorter time frames to be kept in hospital. The Mental Health Tribunal will automatically assess them while they're in hospital and determine whether the patient stays or goes. The Mental Health Tribunal is the old review board. What about community treatment orders? GPs can't commence a community treatment order, but can be asked to confirm a community treatment order written by a psychiatrist as now. It's the same criteria for involuntary care, but a person must be able to be managed in the community and can also be used, a CTO can also be used to prevent a person's physical and mental health from deteriorating. This is new. And a GP can also assist by reviewing a patient, can be asked by a psychiatrist to review a patient and report to that psychiatrist. So a couple of functions really. You can confirm a CTO. You can't start a CTO, but you can confirm it. And you can also, if you're requested, provide a report to the psychiatrist. So let's go to the summary. Remember, you must have seen the person within 2 days to be able to refer them. The referral lasts 3 days. You can extend it if you're in the country. You can refer to an authorised hospital or to another place if you know the psychiatrist will be there. Form 1A is your referral. Form 3A is your detention order, and Form 4A is your transport order. And there are extension orders for referrals, detention and transport, and they're respectively Form 1B, Form 3B and Form 4B. Can I just ask that you discard, get rid of your old Mental Health Act forms on the 30th of November. Clean out your drawers, or get your secretary to clean out your drawers. And can I also ask you to discard your old Mental Health Act 1962 forms? Now that might seem a bit silly, but we occasionally get people sending in folk on 1962 forms. So they're out there somewhere, so just get rid of them on the 30th of November. The forms will be on the Chief Psychiatrist's website. We're making it easier for you now. There will be no password on the forms. You can just go to the website and download the forms, and they are the approved forms. The best place to get them is from the Chief Psychiatrist's website, even though some other agencies such as Health Services and the Mental Health Commission will probably show you that have forms there as well. A reminder that notifying carers is now part of the Mental Health Act, as we talked about. So what do you need to do from here? Every doctor in Western Australia will receive the package Information for Referring Practitioners. It contains a brief 5-page information summary for referrers. It has the Charter of Mental Health Care Principles, and it has a hopefully really helpful referral flowchart. Now, we've run these by some key GPs. Mike Civil, who's the GP rep on the Mental Health Network, Richard Chung, who's with the Primary Healthcare Network, and I think Richard and Mike may have shown those to a few people, and they're pretty happy with those packages. Now, if over time we need to change those packages, we're very happy to do that, but we think they're pretty reasonable at this stage. I'd encourage everyone to read those. Hopefully it's pretty quick to read through those. You can get your forms from the Chief Psychiatrist's website. Be prepared to give your patients information about the Mental Health Act. You can get the brochures from the Mental Health Commission's website. If you want more training, there's an online referrers e-learning package. It takes about an hour to do. It's on the Mental Health Commission website and it's on the Chief Psychiatrist's website. We're getting into a pretty regular theme here, aren't we? The clinician's e-learning package is a much more comprehensive e-learning package. I understand the Mental Health Commission are seeking to get CME points for you for both of those. I'm not sure how they're going, but hopefully they'll get those sorted soon. But you can do a 3 hours online clinician's e-learning package, which is pretty comprehensive for the whole Act. Again, Mental Health Commission website, Chief Psychiatrist's website. We've also done a clinician's practice guide. This is a clinician's translation guide to the Mental Health Act. It's not a training tool per se, but it's a dip-in reference guide. So if you have a particular query, you can go on the Chief Psychiatrist's website, have a look at the clinician's practice guide. It's an e-book, so hopefully you should be able to go straight to the bit that you're looking for rather than wade through it. You can go straight to the bit you're looking for, and hopefully that'll provide you with some advice. The Chief Psychiatrist's standards and guidelines are also in the clinician's practice guide and also on my website. These are 7 standards. It's worthwhile having a look at those just briefly. They apply to mental health services, so not directly to GPs, but they apply to mental health services. The important one is probably to say that the transfer of care standard really does require services, mental health services, to engage proactively with GPs and provide appropriate information in that referral. So hopefully that will be useful for you. The Mental Health Commission has a whole heap of information for consumers and carers. They're doing all the brochures. And if you want some light bedtime reading, or you want an alternative for your Zolpidem, you can read the Mental Health Act 2014, all 300 plus pages of it. But I don't recommend it unless you're really interested. Knock yourself out. Okay, so where do you get your training and resources? They're the websites, Chief Psychiatrist and the Mental Health Commission. This is an important slide, and I put this last. There's a Monday to Friday help desk for clinicians, and we do get calls from GPs. That's run by the Office of Chief Psychiatrist. From the 30th of November, for 6 months, we'll be running a 24-hour clinician help desk. Same number. It's on the website as well, that number, if you need. What we'd suggest is, if you've got a query, call your local mental health service first, because you've got some fairly highly trained mental health staff there who may be able to assist you. But if you're stuck and it's after hours, very happy for you to call us on that help desk line. We don't know how busy we're going to be on that line, but it's there 24 hours a day. During working hours, you'll get our clinical consultant, who's a very experienced mental health nurse. After hours, you'll actually get a consultant psychiatrist. And that, as they say, is that. Any questions?
Hi, it's Laura here. Can you hear me clearly?
I can hear you, Laura.
We did have a couple of questions come through to me. Another one from Sue. What is the form needed for emergency psychiatric treatment?
There is an emergency psychiatric treatment form. Oh, you've got me there. I can't remember which number that one is. it's, again, go to the Chief Psychiatrist website. It's listed there. Just let me have a quick look and see if I can find that on my online.
We can send out the links after
yeah,
the
that might be the
webinar's
best
finished.
thing. We'll send out some links after that. Let me just have a quick look and see if I can find it here. Yep, emergency psychiatric treatment is 9A, Form 9A.
Okay, and another question. In terms of the Act and the term a less restrictive option is available, would Cath French Secure Unit be considered as a less restrictive option?
Yeah, look, that's a really interesting one. Obviously, that's different legislation. That's the child protection legislation that covers Cath French. Could you have someone as an involuntary patient in Cath French? You could only have someone on a community treatment order in Cath French, in the sense that you couldn't have someone, it's not an authorised facility under the Mental Health Act, although it obviously has status under the Child Protection Act. Can you refer someone from Cath French for a mental health assessment using Mental Health Act forms? Absolutely. If you believe someone needs to be referred, someone in Cath French could have a Form 1A, 3A, 4A done, and they're referred for mental health assessment. Hopefully that answers that question.
And one final question from Sean, who had a patient with delusional parasitosis who was at risk of damaging himself financially and reputationally, and didn't have insight but was refusing treatment. He didn't qualify under the old Act. Would he qualify under the new Act?
Look, it's a really good point. That significant harm is quite a broad criteria. There's not been a kind of precedent set or discussion within the Mental Health Tribunal, who'll probably be the ones and then potentially saddle the Supreme Court might kind of define that better. But certainly I would say that if that particular, whilst I'm not giving specific individual advice, if that particular individual was facing significant harm, i.e., for example, they were scratching themselves and creating physical problems because of the parasitosis, and they were getting, ulcers, then that could be considered harm, or in fact that's considered risk to themselves as well. If they were losing all their money, there's nothing to say that you couldn't make a case for that. You couldn't refer that person. So yes, I think you could refer that person for an assessment under the Mental Health Act. Now, how the psychiatrist saw that when they made the assessment would be up to that psychiatrist, of course, how the psychiatrist saw that significant harm. So I can't preempt what the psychiatrist would think when they are making that assessment, but I would think that if you believe the harm was significant enough, yes, you could refer. Any other queries or questions?
Okay, there's no other questions that have been sent through at this point, but if anyone does have anything, feel free to email me them back and I will pass them on.
Fantastic. Well, on my behalf, and thank you very much for your time, and as I said, I'll just remind you of the Clinical Help Desk, which is available, and also the websites, the Chief Psychiatrist's website and the Mental Health Commission's website. Thank you very much.